monthly Board of Adjustment meeting for Buncombe County. Welcome. We'll start with our board members for introductions and move to staff.
Joel Mazelis.
Paul Wilczynski.
Craig Allen.
Andy Ball.
Carla Barnard.
Mark Diaz.
Tom Bell.
Thank you.
Jason Payne.
Dana Alley. Amy Broughton.
Griffin Kearns.
We would like to extend our warmest welcome to Mark and Tom as well for joining us and being here for the first couple meetings. Yeah. Tom, did you want to introduce yourself?
Yeah, I'm Tom Belt. I live in Weaverville. My wife and I have been here 8 years now. I'm a retired physician and do a variety of activities. Yeah, I'm happy to be on this board and look forward to serving.
That's great. We appreciate your enthusiasm and your expertise.
Turn on the microphone. Okay.
Yeah, there you go. Yeah.
My first lesson. Okay.
That's right. Thanks so much, Tom. Moving now to any announcements from staff.
Yeah, so we've had requests from two applicants, one for the via variance ZPH 2025-00032, the first item on the agenda, to request a continuance. The applicant was not able to be here to January, correct, Griffin? They're seeking Griffin, or to January. And then agenda item 3, ZPH 2025-00041 for the Assad variance. The applicant is not present. There is no one here for this. And quite frankly, the fee has not been paid, so no determination should be made on this.
Sure.
However, the county is requesting that case be continued to a date uncertain.
Okay. Have they been in communication there this month at all?
We have not had any communication, and the fee has not been paid yet, so we do not know anything more at this time.
Let's, after the board's action, let's keep it on the back burner until they take care of that, and then we can calendar them after that.
Thank you.
Right, yeah. Is there a motion on the villa variance, the first item, with regard to continuing to January?
Motion to continue.
There's been a motion. Is there a second?
Second.
All those in favor, please say aye. Aye. Any opposed, nay? Thank you, that passes. Is there a motion on the Assad variance related to a continuation to a date uncertain?
So moved. I'll make a motion.
Second.
There we go. Motion and a second. All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you so much.
Thank you.
Let's move to disclosures of conflicts of interest and ex parte communications. Any member of a board exercising quasi-judicial functions pursuant to North Carolina general statutes shall not participate in or vote on any quasi-judicial matter in a manner that would violate any person's constitutional rights to an impartial decision maker. And permissible violations of due process include, but are not limited to, a member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, close familial, business relationship, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. Start with Joel.
No.
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 Nope.
No.
No.
Thank you so much. And moving to our public hearing section, this is a quasi-judicial evidentiary hearing, and that means similar to a court hearing. State and local law sets specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision upon the competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. If you'll be speaking as a witness today, please focus on the facts and standards and not personal preference or opinion. We value a transparent process and encourage the community to remain engaged and participate. But given this is a hearing on the record, there are certain topics and areas that limit the type of testimony we can receive from members of the public without standing. Expert testimony for certain topics, the board needs to hear opinion testimony from expert witnesses. These topics include projections about impacts on property values and projections about impacts of increased traffic stemming from the proposed project, Individuals providing expert opinion testimony must be qualified as experts and provide the factual evidence upon which they will base their expert opinion. Moving to ZPH 2025-00034, Oakmoss Mobile Home Park Special Use Permit. And we have Planner Thana Alley to present that case.
Please raise your right hand and state your name.
Dana Alley?
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so omitted.
This is a review of ZPH 2025-00034 Oakmoss Mobile Home Park. The applicant is Mike Anderson of Carolina Engineering and Development. Property is located at 14 Oakmoss Lane and consists of 7 parcels in total. It will be serviced by public water and sewer. Property is zoned R3 residential. Composes of a 13-unit mobile home park across 9.93 acres. There are no deviations requested. If approved by the board, staff recommends the following conditions of approval, which I will summarize. All parcels included in this development must be recombined before submission of the master site plan review permit. Project must be constructed as depicted in site plan.
The initial questions for staff.
Are we gonna hear from, an engineer or somebody that we can talk to about ratios on development and open space? Because if not, we can ask staff.
Yeah. The applicant,
Yeah.
most likely
Okay.
has that
Okay.
prepared. Yeah. Thank you, Thana, so much. Anyone here today to speak on this case and assert standing? Any standing applications? Any on file for staff?
We did not receive any.
Okay, wonderful. Anybody in the audience? And twice, 3 times? Thank you so much. Welcome, Mr. Noor.
Hi, good morning, members of the board. My name is John Noor. I'm with the Robertson Stevens Law Firm, and I represent the applicant on today's special use permit petition to the board. With me today are the principals with the applicant, Ms. Andrea Golden, Ms. Ingrid Johnson, and we will have an engineer who's going to be testifying remotely today due to a conflict. So you should, Ms. Barnard, be able to address all your questions to Mr. Anderson, as well as our appraiser. We'll go ahead and jump in unless there's any initial questions with Ms. Golden, please. The binder in front of you has all of the materials that were also made available to you electronically. The tabs correspond with the exhibit numbers, so tab 1, exhibit 1, tab 2, exhibit 2.
Okay. Thank you. May I approach Ms. Golden? We'll start by swearing you in.
Okay. Please raise your right hand and state your name.
Andrea Golden.
Do you swear or affirm to tell the truth and nothing but the truth?
Yes.
Thank you.
Welcome.
Hi, good morning, or good afternoon.
Good afternoon, Ms. Golden. If you don't mind, introduce yourself to the board and the role you have with the applicant for the special use permit.
Sure. My name is Andrea Golden. I'm the director of a neighborhood-based organization called Poder Emma, and I'm an Emma community resident.
And specifically related to the applicant, you're one of the principals in that group that will be developing the site, correct?
Yes.
Okay. Can you tell the board a little bit about the 13 units and the affordability levels and other kind of background characteristics? We'll obviously get into the details with Mr. Anderson.
Sure. I mean, it might be helpful just for context. Poder Emma, our focus is to protect affordable housing in the Emma community, and the particular kind of affordable housing that we focus on are mobile homes and mobile home parks. So we have in the past successfully worked with 4 existing mobile home communities to convert them into resident-owned, permanently affordable housing. We are set to begin new construction on a park that is adjacent to Irwin Middle School that will add 38 new units of permanently affordable resident-owned housing, and then with this project adding an additional 13.
Okay. So the 13 units here, and I know we'll hear more from Mr. Anderson, these are situated between 2 existing mobile home parks, is that correct?
Yeah, I mean, the Emma community generally is very mobile home dense. Some of you may recall we're one of the most mobile home dense census designated places in the entire country. And this particular part of the Emma community, which is along North Louisiana Avenue, is where we have some of our largest mobile home parks. So where we're looking to build this park would be immediately next to Brownwood Mobile Home Park, in between Brownwood Mobile Home Park and Hazelwood, which is a mobile home subdivision, and then across the street from Mosswood Mobile Home Park.
If staff don't mind, if you could switch over the camera to my device, I will throw up something, please. Okay, is this the site you were referring to, Ms. Golden?
Yes.
I think this has been provided in the materials. This is Exhibit 5, but these are the maps. Immediately surrounding the proposed site are a number of different mobile home units currently in existence, correct?
Yes.
Okay. Is there anything else you'd like to share with the board before we move on to Mr. Anderson?
Let me think real quick. I do just want to, can I say something particular about our housing model?
Oh, of course.
It is really unique because what we do is focus on families that typically have been lifelong tenants and don't have a path to ownership, to be able to both build equity for their families through this cooperative ownership model while permanently protecting affordability for future generations. So it's a very unique model. And something that I think is just really particular about it that we're really proud of is also just the sense of pride that we see our neighbors feel as you go from being a tenant in the place you live to owning it. And so we do a lot of both. There's the financial benefit to becoming an owner through this model, but there's also kind of the social benefit of living in a community where you participate in the design of common and share spaces and ensuring that residents have a really high quality of life by creating that together. So we're really, really proud of this affordable housing model.
I think those would be my questions for Ms. Golden, unless the board has any.
Any questions?
Okay, and if we could switch over to the Zoom link.
Thank you.
There we go. I think there's Mr. Anderson.
Good morning.
I know Griffin will need to swear him in.
Please raise your right hand and state your name.
Mike Anderson.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Mr. Anderson, can you give the board a little bit of background on your education, training, and licensure, please?
Sure. I'm a graduate of Michigan State University with a degree in biosystems engineering and a joint degree through the College of Natural Resources. I've been practicing as an engineer in the state of North Carolina for 27 years. I also hold a license in South Carolina. I am the owner of Carolina's Engineering and Development, and I'm the engineer of record for this application.
And just for clarity, I think you had indicated you practiced in North Carolina. You are a licensed North Carolina engineer in addition to South Carolina, correct?
Correct.
Okay. Have you ever been qualified as an expert in the area of civil engineering before a quasi-judicial body like the Board of Adjustment or this body, in fact?
Yes, I have.
Approximately how many times?
A dozen?
Okay. At this point, we would ask that Mr. Anderson be qualified as an expert in the area of civil engineering.
Hearing no objection, so tendered.
Okay. Mike, if it's all right, if I call you Mike, we have you up on the screen as opposed to the site plan, but I'd turn the board members to tab 3 that I think is going to be in your binder or in your materials. Mike, do you mind walking the board through the development plan and its components, please?
Sure, absolutely. We are going to be recombining some properties. I'll just talk about the overall scope. There are 2 existing single-family homes on the northern edge of the property along Oakmoss Lane. We will be subdividing those out so that they're standalone single-family homes. One of the single-family homes also has a dwelling above the garage, so it'll be an accessory dwelling unit. So those will not be a part of the mobile home park. The remainder of the property will be combined into a single parcel for final staff review and approval, assuming that we're able to get approval today, hopefully through the Board of Adjustments. The access to the park will come off of North Louisiana Avenue. We are currently under review for an NCDOT driveway permit for that access. The road will meet all manufactured home park requirements. The road is a little over 500 feet, it's closer to 600 feet, and we'll have a T turnaround style turnaround at the end of the road that will meet fire code standards as requested or required rather by the fire marshal. We have a maximum grade of that road of around 14.8%. We have a existing stream along the southern edge of the property. We will have a 30-foot undisturbed buffer along that stream. That area is also designated as open space, so we can create a foot trail for the residents to be able to walk along that area. In addition to that, the owners have some plans to do additional playground equipment on the property, but at this time we hadn't decided the best place for that, so that will be likely coming in addition to this open space area. The property will be served by City of Asheville Water. It'll have a master meter near the right-of-way of North Louisiana Avenue, and then have private sub-metering beyond that. We will have a public sewer extension that will be owned and maintained by MSD. Stormwater will be provided in accordance with Buncombe County and NCDEQ standards. Will include detention of the pre and post development runoff rates for a 1-year storm event, and will also provide water quality for the first flush of rainfall. That will discharge at the southern edge of the property. In order to provide the pads for the individual homes, we will have a decent amount of grading on the property to create those pads. We will have driveways that provide a minimum of 2 parking spaces for each unit, and we have a few retaining walls that are all under 10 feet that will help provide transitions between some of the pad elevations. And if you have any questions for me, I'd be happy to answer those for you.
Just a couple follow-ups from me, Mike. One of the questions I failed to ask Ms. Golden was a community meeting was done as part of the application process, correct? And I think you attended?
That's correct.
And during that meeting, what feedback, if any, did you receive from community members who attended?
We received quite a bit of positive feedback. It was really informative. One of the standout comments that we received was from a manager of a large neighboring mobile home park that gave us some tips on neighborhood safety, particularly in regards to dumpsters and trash. They also gave some feedback on stormwater runoff coming off of North Louisiana Avenue, which is a DOT-owned and maintained street. But they've noticed some concerns in adverse weather over the years. So that was helpful for us to make sure we can accommodate and mitigate those concerns.
So no negative.
Generally, people were positive.
Was there any negative feedback at all at the community meeting?
Nothing that was expressed at the meeting.
Okay. Turning to a couple of the standards, I think you mentioned the playground or recreational amenity area. One of the reasons, and just confirm this, that is a condition the applicant is willing to have, whether it be playground or other picnic, sort of recreational space. But is it the developer's intent to allow the residents to sort of be able to pick out what recreational amenity would be best suited to their needs and then place that on the property?
Yes, that's my understanding.
Okay. So at least for the board's benefit, we're willing to have that be listed as a condition for a recreational space, but we would request the flexibility to allow the residents to locate it and choose between a number of different options based on the needs of the community. One of the other you mentioned was the DOT driveway permit. The developer is also willing to have that approval be a condition of the permit as well, correct?
Yes.
Okay. And working through the standards, so that I know you're very familiar with the special use standards from a civil engineering perspective under 78-677 G 1 through 11. Do you have any concerns, or what is your professional opinion on whether this development meets those standards from a civil engineering perspective?
I believe that we meet those standards.
Okay. I am happy to go into more details with the board, but at this point, I think we would open it up for questions and then potentially some follow-ups based on the information that's solicited from the board.
Board questions?
Yeah, I've got some questions. Can Mike hear me okay?
Yes, I can.
Okay, great.
And I just note, Mike is not on the screen. If we could flip back, that might help Ms. Barnard.
I'm good. So it's R3, and the site is 3.1 acres total, is that correct?
Let's see. I believe it is.
I'm trying to see on here, it's really tiny, but it says pre-development pervious surface is 3.1 acres.
The total parcel size is 3.9 acres.
Okay. Okay, so it's 3.9 acres, and there's only 2.37 acres being disturbed?
Correct.
Correct, okay. And then in R3, am I remembering correctly, that's 12 units per acre as of right?
I believe that's correct, yes.
Okay, so they could have 40-something units on this as of right?
Yes, as of right. The mobile home park standards require a minimum footage of lots of 6223 square feet. So based off of that minimum requirement, we would not be able to meet the maximum density allowed with the underlying zoning. Would be significantly less than that.
Okay, but as far as the ordinance is concerned, it's like you could have 40-something, and this is only 13.
That is correct.
Correct, okay. And then I can see that there's a unit on the southern boundary that sits over an underground water quality and detention system, and I'm assuming that's there because you're allowed to do that and there's an engineered solution, but can you give us a very layperson's understanding of why that's okay and safe?
Sure. We typically would not do that if we had a permanent structure. So if we had a stick-built home, I would probably not recommend that as a solution. But in order to align with the goals of the community and to keep rents and ownership prices at the price point that align with the goals of the development, if there were to be a maintenance concern or issue with that system, the home could be relocated temporarily to do that work. The risk is very, very small for that to be a concern. And so it was my opinion in discussing this with my client that it was a worthwhile risk in order to align with the goals of the project.
But to be clear, like, as far as code is concerned, that would not be safe for a stick-built, site-built home and a foundation, but it's deemed to be okay for somebody living in a mobile home?
Correct, because there's no danger to anybody living in the residence. These systems are highway loaded for 20,000-pound axles to be placed on top of it. So structurally, there's no concern. There's no concern with flooding. There's no concerns with safety to the residents. No concern with damage to property as part of that. So I think it's a worthwhile consideration and use.
And your firm, or you are the one that engineers that, or is that like a different type of expert that engineers those things?
Nope, this will be me, and this will fall under my seal and my professional abilities, yes.
Okay. Thank you.
You're welcome.
Other questions?
Couple of questions, Chair. Mike, this is Craig Allen. Just clarification, you had mentioned that retaining walls would be 10 feet, but yet on your diagram, you've got a reference to 12 feet. Is just for point of accuracy?
Oh, thank you. Did I, well, I hate that if I misspoke that. I was thinking that we were below
It's
10 on all.
adjoining to lot 13. Just,
Appreciate that. I will look at this. This is a preliminary design, so I'll try to get that below. Yeah, there that is. My apologies. We'll try to get that below 10 feet. But if we do hit that, all walls will be designed by a structural engineer where code requires that. There are additional requirements by the county once you hit a 10-foot height. So we will make sure that we're obtaining all relevant approvals and meeting all ordinance requirements.
okay, then.
Mr. Allen, we'd be willing to make that as a condition that it will either be under 10 feet or if it is above 10 feet, otherwise comply with the ordinance requirements for design.
Thank you. A clarification on lot 15. The driveway that, I assume that's the existing driveway, not a proposed, the existing driveway seems to protrude into lot 9 and also adjoin very closely to lot 10. Is that an issue?
We have, I may ask for Mr. Nord to help address this more precisely. We've had discussions about potentially relocating a driveway for some of the homes. As far as encroaching into lot 9, there's no technical reason why that would be a problem. Easement could be provided for maintenance purposes, the grade works. There's no standards that are not being met because of that encroachment. Mr. Nord, is there any other additional information that we should add for addressing that question?
I'm happy to address that from the developer's perspective. So in an encroachment area, and I'll just sort of pull it up here so everybody can see what we're talking about. If we see that, what I think you're talking about is this right here.
Yeah,
Mr.
and
Allen?
again, I'm no expert,
Yeah.
nor attorney or engineer. It just, as I look at that, it just begs the question of, is that an issue? And if so, how is it going to be remediated?
Yeah, so what this would be, it'd be considered a driveway if this were split at least between, let's say lot 15 is sold off. So one, it's typically resolved through an encroachment or other type easement agreement between lot 9 and lot 15 that would allow the driveway to stay in the location where it currently is. And then the owners of lot 9 and lot 10 would buy subject to that encroachment. I don't believe that is it impacts the zoning ordinance requirements in any way, but that's typically how that's resolved. It's under common ownership at this point, so when it is sold out, it's resolved through those vesting deeds that go out to the owners of lot 9, lot 15, and it's spelled out exactly how that will be handled into the future.
So Amy, was there anything that you heard that would cause you to be concerned about resolving this driveway over the boundary on the property?
Based on the information that the engineer gave, I don't have any concerns, but I would have to rely on his expertise.
Okay. And then the last question, any setback issues? And if so, then are they not resolved, I assume, through the repartitioning of the properties?
So if you're referring to setback issues, usually setbacks are those standards apply to structures and not driveways or other non-structural elements. Again, that's what gets resolved through that encroachment or easement agreement that would say, yeah, we understand that the driveway crosses here, but this is how we'll handle it.
I apologize. I switched to a totally different
Sorry.
question, not related to the driveway. I was just looking at, I don't know what it's labeled as, lot 12, and the proximity to the property line in the rear. And again, is that not an issue with the readjustments of the properties and parcels?
There's a minimum 15-foot setback between the rear property line and where the mobile home can be located, and we are exceeding that setback requirement.
Mike, I missed that part. You are what with that requirement?
We are exceeding that requirement.
Okay. Those were my questions, Mr. Chair.
I had a follow-up question. So I can see that the minimum space between units is 20 feet. Is there anything, what is the standard in the ordinance, or is there none for mobile home parks?
20
On
feet
minimum
is the
spacing?
minimum.
Pardon?
Yeah, 20 feet is the, I'm sorry. 20 feet is the minimum spacing required through the mobile home ordinance.
Okay, and there's no variant, you guys, it said no variances. Okay, that's fine, that's all
No
good.
variances. If I may just add one last point too, I would like to thank the board for allowing me to meet with you today remotely.
Any other questions? Thank you.
Okay, thank you, Mike. If you don't mind staying on the Zoom call, just in case there's any follow-up questions that come up from the board, but I think we're done for now.
Happy to.
Okay. At this point, we would call our next witness, who is Ms. Laura Gourlay, as our appraiser.
Please raise your right hand and state your name.
Laura Gourlay.
Do you swear or affirm to tell the truth and nothing but the truth?
I do.
Thank you.
Good afternoon, Ms. Gourlay. Can you give the board a little bit of background on your training experience and education?
I went to, I got a BBA from the University of Georgia, and then have done numerous appraisal courses to become a certified general appraiser, and then I have 3 appraiser designations.
Is one of those the MAI appraisal designation, which is generally considered sort of the top or preeminent sort of designation within the field?
Yes, I have an MAI designation.
Okay. Have you worked on appraisals within both the commercial and residential context?
Yes, I have.
Okay. Approximately how many appraisals have you performed throughout your career?
1,500 to 2,000.
Okay. And I believe you said you've been in the appraisal field for approximately 15 years, is that right?
15 years,
Okay.
yes, sorry. I don't know that I said that, but yes, 15 years.
I don't believe you've been qualified as an expert before a quasi-judicial board like the Board of Adjustment before, correct?
I have not for the Board of Adjustment, but I have been deposed before, and I have been qualified as an expert witness
In those Superior Court cases? Or I should say in those litigation matters?
in litigation matters, yes.
Okay. At this point, we would ask the board to qualify Ms. Gourlay as an expert in the field of appraisal services.
Hearing no objection, so tendered. Thank you.
Okay. Ms. Gourlay, it's common for the board to hear testimony from appraisers, particularly related to the SUP standard, which is standard number 2, whether the proposed use will or will not be detrimental to the public welfare or injurious to property or public improvements in the neighborhood. Did you do that analysis for this particular project?
I did complete that analysis for this project.
And I think that's what we have is marked as Exhibit 7. That means that'll be tab 7 in your binders. We'd ask, I think all of the materials that were provided previously have already been admitted into the record, but we'd ask that this be admitted. Ms. Gourlay, can you walk the board through the analysis you performed to come to a conclusion on the impact of the proposed use?
Absolutely. So obviously you have my report in front of you. In the process that I perform, I look at the subject property and the surrounding area. And then I look for other comparable properties that are in the market that I can use to analyze and get market data to either support or not support the estimate or conclusion that it has an impact or not.
And before we go into the details of what you looked at, what was your conclusion overall on the impact of this development on the surrounding neighborhood?
My conclusion was that it had no impact.
Okay.
Or
And
did
would-
not have a negative impact.
Would not be injurious
Would
to
not
the
be
property?
injurious.
Okay. Let's look at the specific comps you looked at, and if you could share with us or orient the board here. I've thrown up, I think this is going to be on page 5. What are we looking at here?
What we're looking at here is the subject property and its location in the overall Buncombe County community.
And I think it's been noted that the surrounding parcels also house mobile home parks, and what impact does that have in your analysis?
repeat that again. What,
So the surrounding areas are also mobile home
Right.
parks. What impact, how did that factor into your analysis?
yes, well, so given the fact that the property is surrounded pretty much on all sides by similar housing, my conclusion was that there was not a negative impact by adding this housing.
Looking at the specific comps and sort of turning to, this will be, I believe it's page 14 in the report. Can you talk to us about why you picked comp 1?
So comparable number one was an existing mobile home park that is continuing to expand. So it, on the MLS and other internet sites, is advertising adding product to the mobile home park. So that was why this one was chosen, because it is an existing yet expanding mobile home park.
And did you also pick mobile home park comparables that had been approved by this board, or their expansions had been approved by the board?
Comparables 2 and 3.
Okay.
Both were approved by the board.
So 2 and 3 were approved by the board previously. Comparable 1 is an expansion, and I think you had said you looked at sales that occurred after the expansion and compared them to those before, and that your analysis resulted in what conclusion for comparable 1?
For comp number 1, the conclusion was that there was not an injurious effect by the expansion of the mobile home park in the properties. I kept my research to the properties within 1 mile of the subject.
Okay. Looking at comparable number 2, which is on page 15, why was this a comparable that you selected?
So comparable number 2 was, had a special use permit that was issued by the board in 2021, and they began adding homes in 2022. And so I looked at the data from that point on to attempt to assess whether there was any injurious effect, and my conclusion was there was not.
Okay. And what about comparable number 3?
Comparable number 3, in my opinion, is the most similar to the subject because it was not existing, and it's a new approved mobile home park that was approved by the board. And I, again, looked at the same information. Also, the similarity for comp number 3 is it is in an area that is also surrounded by several other mobile home parks. And again, my conclusion was that it was not injurious.
Are there any other aspects of your analysis that you want to highlight for the board and how you formed your conclusion?
Well, so the 2 main things that I looked at were overall property values within 1 mile of the comparable, and then the second piece that I looked at was resales of properties in that area, because looking at a property that is sold and then resold during that time period is one of our better ways of really looking to see if the values are increasing in an area more specifically and more closely. So those were the 2 methods that I used on both of those. And that's it.
And again, your conclusion overall was that you were not able to identify any evidence based on the comparables that would suggest that the proposed use would have an injurious impact on property or public improvements in the neighborhood, correct?
That is correct.
Okay. Those have been my questions for Ms. Gourlay.
Board questions?
I have a question. Welcome. So I think you seem like you've pulled some good comps, like comp number 1 and number 3 in particular seem very strong. And I can see the methodology of looking at the, immediate area and what happened with home prices. But the next step for me would be to know how that 1 mile area performs against the rest of the market, and whether there's a variance for that market. And I was just wondering if you had looked at anything like that, or maybe using comp number 1 as an example, the percentage variances there in the last column, did they largely track with how the rest of the market was performing?
So I did not do any sort of specific analysis where I pulled another area of the market to look at it, but in my review of the overall markets in Asheville, again, without doing the actual research, I can't give you a 100% sure, but it appeared to follow the trends that I've been seeing in the market.
Okay. Thank you.
Other questions? Thank you so much.
At this point, we don't have any additional witnesses. I would just briefly like to offer the opportunity for the board to ask any follow-up questions that you may have not had at the tip of your tongue when a previous witness was available. But then close with this to say, I think this is, on behalf of my client, I think this is a great project in a community that already has a high concentration of mobile home and affordable type housing. 71% of the residents within the Emma community live in affordable mobile home housing. This builds on that and then does it through a product that also allows home ownership. The development as a whole will provide that affordable housing, but also, as I indicated before, the developer intends to provide public amenities for the residents that will be informed by the residents on what they would like to include in that space. And we think this is the perfect kind of project for this type of tract within the location where it's being set. We'd ask that you approve the special use permit. Happy to answer any questions you might have.
I have, sorry,
Please.
as usual, sorry. So when we talk about the word affordable, there are different meanings to that. So are you deeding this as things I want to know are like, is this actually being deeded as affordable housing? Or are we just saying, oh, mobile homes are a form of affordable housing? Or is this a LIHTC or I don't know, whatever,
Yeah,
like
that's
what
a
type
great
of development?
question. It's not a LIHTC. The affordable housing model, and if I say anything that is too, this is the world we spend all of our time in, so if I say something that doesn't make sense, please let me know. But the affordable housing model that we develop are called limited equity cooperatives. And so the affordability is based on the neighborhood median income of the Emma community, not the larger Buncombe County median income, because when we look at affordable housing products that might get proposed somewhere in the county at 80% AMI, that's not affordable to the Emma community. So we look at median income for the Emma community and then ensure that the total housing cost cannot exceed 30% of that median income. So we're generally looking at housing that is ranging between 30 and 50% AMI target, because that's the more accurate representation of income in the Emma community. The way that it is restricted is both bound in the operating agreements of each individual housing cooperative that we help get started, as well as with a right of first refusal from, this is where I don't want to get too technical, but from a parent cooperative, so that if at any point the existing residents were to say, we're done, the property can't go back onto the speculative market. It has to then be able to be acquired by the parent cooperative for the actual value of the property, which what we do is we take the value at purchase plus improvements that were made, but the cooperative itself can't realize any speculative gain in that transfer of property. So we have extensive legal protections built in. We founded the model by working really closely with a professor at Wake Forest Law to ensure both the ability for residents to build equity, but restrict the ability to get a speculative gain, which is what keeps it affordable for future generations.
Okay. And so when we say future residents have ownership, it's not ownership in an individual
No.
lot unit. It's a part of the whole, it's like a common ownership
Yes,
thing.
we don't subdivide and have people own individual lots. What it is that you have a member share in a housing cooperative, and that gives you the right to live there and the opportunity to build equity.
Okay. And if for some reason everything went upside down and inside out and the cooperative collapsed, is there anything to stop that property from conveying in the future to be like market rate?
Yes, it's both written into the financing, so we use a kind of financing that is not typical, and we also finance through a national financial cooperative that's named Seed Commons. So it's restricted in the financing, which tends to be on a 30-year term, but it also is restricted by that right of first offer and refusal by a larger community cooperative so that it cannot return to the speculative
But
market.
there's never anything in the deed. So if the cooperative collapsed, maybe they pay off, their loan paid off, so there's no
Yeah.
borrower restrictions. Can the property then become a market rate property?
If I can help in what I'd
Sure.
heard here, that there is a recorded restriction with the larger national cooperative to where if that scenario were to come out, that national cooperative has the right to come in immediately and purchase it to prevent that from hitting the market in an unrestricted way, if I heard you
Yeah,
say
it's-
that
But if you
correctly.
never put it on the deed for the underlying land, then there are like scenarios. And the only reason I'm asking is because we have applications that come before us, and the word affordable is like banded about a lot.
Yeah.
And people have different understandings of that. And you can have boards like this approve higher density projects with the idea that it's like a permanently affordable thing, just like people, hear city council approving affordable was only for a short time limit. So I was just more
No,
curious
think
and
it's
for
a-
our
I think it's a
education.
great question, and currently the way that it's restricted is through the relationship of operating agreements between cooperatives. There's not an opposition to deed restriction. In fact, we had been previously working with Buncombe County pre-Helene at looking at a deed restriction tool that could also be linked to the way that property taxes impact these affordable housing developments. It got put on pause pre-Helene, and we'd really like to revisit it. Yeah, so
And
there's not.
it's
there's
not
an-
within our purview of decision-making as far as I
Sure.
know. I'm just asking because I want to
Yeah,
understand.
I just want to make sure it's clear, there's not an opposition to deed restriction. We are working with the county and with our legal team to look at what might be the right way to use a deed restriction that protects permanent affordability in the best way, but not out of a lack of willingness to do so.
And the right of first refusal will be recorded because it has to be
Oh,
for
yeah,
the
that's
larger
right. Mhm.
financing, not financing, but the larger
Yes, for both, for the
cooperative.
financing and for our development
So it's
model.
not, theoretically, yes, they could decide not to exercise their right of first refusal, but that is an incredibly small likelihood in the probability of things.
Thank you for explaining it.
Any other questions?
Yeah, just one quick question here to confirm. I think I noticed in the paperwork somewhere that because of the size of this, a traffic analysis wasn't necessary. Is that correct?
That is correct. The size of the unit did not require it. However, the DOT driveway permit does go through DOT approval. And we've offered that as a condition for the project so that DOT will have to sign off on this connection in order for us to proceed.
Is that a staff condition or where is that written?
I don't recall it being one of the conditions that Ms. Alley proposed, but I mentioned it in case it was a concern for the board that we are willing to have that. I know that's a typical standard thing that you all ask for, so
Yeah.
we have no opposition to that.
I think that's one of at least two. The other was the retaining wall. Was there another?
As I would recall them, I sort of heard them as three. One was the driveway permit.
Correct.
One was the retaining wall that we will either be below 10 feet or if it exceeded 10 feet would otherwise meet the county's ordinance related to the design features for walls in excess of 10 feet. And the third, and I don't know where you all have landed on this, is that there will be recreational space provided, but that we wanted the flexibility to allow residents to pick the what and where of it.
Thank you for the review. Yep.
Anyone here from the general public who wishes to speak on this case as a witness? Any witnesses? Anybody signed up in advance, Griffin? Okay, thank you.
Thanks.
Any final board questions? Thank you all very much. This time we'll close the public hearing and open up to board discussion, deliberation.
Mr. Chair, I think it's a well-prepared project. I think it meets the needs of the community. I appreciate the cooperative approach and the organization that's been put forth, not just for this property, for others that have come before the board. And it has my support.
Thank you.
Yeah, I think it's a relatively low-density project, all things considered. I also don't think we need to bother with the restriction around recreational space, because the reality is they've got like an acre in excess of, and if it's going to be limited to owner or resident discretion, then I just don't know that there's much of my teeth or point in adding that. But that's just my take.
Other thoughts?
Mr.
All
Chair.
right, we're ready.
Based on the evidence presented to this board, including the following exhibits: the petitioner's application, the submitted development plan, the GIS maps, the staff report, testimony presented at the hearing. And where do we insert the two conditions, Amy?
I put them in the order.
I'm just saying.
Section C concerning the following conditions being necessary. And what I added was that the applicant would have to obtain a driveway permit from the North Carolina Department of Transportation. They would have to erect a retaining wall under 10 feet as necessary and provide for recreational space as requested by the residents.
Or if it exceeded 10 feet, they would be in compliance with all requirements for that retaining wall in excess.
Sure.
Okay.
Can I have that language again, please?
Wall would be either below 10 feet, or if it exceeded 10 feet, comply with the county zoning ordinance regarding design of retaining walls in excess of the 10-foot standard.
So continuing.
Are those standards in the zoning ordinance?
I guess I'd say the county ordinance.
Yeah.
Forgive me, there's the retaining wall section that relates to the design of walls in excess of 10 feet.
All right, so continuing on, the petitioner's application, the submitted development plan, the GIS maps, the staff report, the testimony presented at the hearing, and the two conditions agreed to by the applicant as noted in the final order. I move that this board adopt the following findings of fact: that this matter was properly advertised, is within the board's jurisdiction, and is ripe for its consideration; that this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in the Buncombe County Code of Ordinances, Section 78-621, subparagraph 3.
There's been a motion on findings of fact. Is there a second?
One
Yes, please.
very, very small question. It sounded like Amy was including the condition about the recreation, and
Yeah.
if that's true, that would make 3 of them.
Yeah, I think we just want the first two.
I think we just.
And next the
two.
third.
Yeah, 2.
Okay.
Thank you for that clarification. All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you.
Mr. Chair, based on the foregoing findings of facts and for the reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
There's been an approval motion. Is there a second? Second. All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you very much. We'll ask if staff has a order for us to consider.
I do. Griffin, what's the current protocol to hook up your computer? It looks like it's changed since the last time I was here. It is just that one? Okay. Got it. Come on now. Dispensing with the caption. This matter was properly noticed and advertised and was within the board's jurisdiction. The applicant applied for a SUP pursuant to the zoning ordinance of Buncombe County. Property is located in a residential R3 zoning district, and that the applicant and all parties withstanding, if any, were given the opportunity to offer oral and documentary evidence. The board finds as follows: that the land within the PUD will be under single ownership or management by the applicants, that the density is consistent with the intent of the district in which it is located and conforms to that permitted in the district, that the land uses are compatible with and do not violate the intent of the zoning district, that the proposed land meets minimum requirements for land development as follows. The minimum lot size and requirements for interior setbacks do preserve the spirit and intent of the section and comply with the density requirements. Proposed heights as set forth in the application do comply with the spirit and intent of the section with respect to the total development plan. The board finds that the minimum distance between buildings will ensure adequate light, air, privacy, and space for emergency vehicles, that the development does provide reasonable visual and acoustical privacy for all dwelling units. Fences, insulation, walks, barriers, landscaping will be used for the protection and aesthetic enhancement of property and the privacy of occupants, that the structures located on the perimeter of the development will be set back from property lines and rights of way of abutting streets in accordance with the provisions of the zoning ordinance controlling the district. This board finds that proposed parking does comply with the spirit and intent of the section. As applicable, this board finds that the conveyance and maintenance of open space, recreational areas, and communally owned facilities are in accordance with NC Gen Stat 47-1 concerning unit, which is the Unit Ownership Act. The board finds that the building envelopes are shown in the submitted plans depict the maximum expanse of proposed footprint of the structure, that pursuant to 78-677G of the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for at least the following as it relates to. Number one, the proposed use will not adversely affect the health or safety of persons residing or working in the neighborhood, that the proposed use will not be detrimental to the public welfare or injurious to the property or public improvements. Satisfactory ingress and egress for the proposed use of the property and proposed structures has been provided. Provision of off-street parking and loading areas where required with particular attention to the Buncombe County zoning ordinance have been arranged for. Provision of adequate and proper utilities with reference to locations, availability, and compatibility have been arranged for. Provision of buffering, if deemed necessary, with reference to type, location, and dimensions have been arranged for. Signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with properties in the district. Playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways have been arranged for. Buildings and structures are acceptable. Buildings and structures with reference to location, size, and use are acceptable. Hours of operation with particular reference to protecting and maintaining the character of the neighborhood are acceptable. The following conditions are necessary to ensure that the proposed use will conform to the requirements and spirit of the Buncombe County zoning ordinance. The property must be recombined prior to submission of the master site plan. The project must be constructed as depicted in the site plan. Prior to commencement of land disturbance and construction activity, the applicant shall submit a site plan development permit for the entire project, indicating the following: the exact location of all buildings and structures, accessory structures, commercial lighting plan, buffering, landscaping, and parking lot landscaping, retaining walls, easements and rights of way, approved 911 road names, any other conditions of site development approved by the Board of Adjustment, copy of approved permits from the U.S. Army Corps of Engineers, the North Carolina Department of Transportation, and the North Carolina Department of Environmental Quality where applicable. Specifically, the master site plan approval shall not replace the requirement of pulling an individual site plan permit for each building or structure within the development. The additional requirements were that the applicant must obtain a driveway permit from the North Carolina Department of Transportation and must erect a retaining wall under 10 feet as necessary, or if said retaining wall will exceed 10 feet, will comply with the Buncombe County ordinances governing retaining walls in excess of 10 feet. And I'm going to omit the section I added about recreational spaces. Finally, the applicant must agree in writing to those conditions prior to the commencement of the site. Based on the foregoing findings of fact, the board makes the following conclusions of law: that the applicant's request for a special use permit, together with the imposition of the conditions found above, which are incorporated by reference as if fully set forth herein, meets each applicable requirement for the Buncombe County zoning ordinance. Now therefore, based on the foregoing findings of fact and conclusions of law, the applicant is hereby granted a special use permit to establish a planned unit development on the property as requested, subject to the conditions referenced in this order, which are incorporated herein, this 10th day of December.
Are there questions, changes, or motion on the order?
Motion to approve the order?
There's a motion to approve. Is there a second?
Second.
Your motion and a second. All those in favor, please say aye.
Aye.
Any opposed? That passes. Thank you all very much. Congratulations. I believe our last item we skipped right over at the beginning of the meeting was the minutes from last month. We do have those in our email boxes.
Correct. And I do want to note that earlier today, I did make corrections and send corrected minutes.
Okay, thank you for that. Any comments on the minutes?
Motion to approve the minutes?
Second.
Motion to approve and a second. All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you very much.
Motion to
I
adjourn?
believe we're all set for the holiday. So anything else from staff? Anything else from the board? John?
I just want to thank you all for your consideration today, and if you don't want your binders and materials back,
Thank you very much. Anything else from the board? All right, we'll take a motion.
Motion to.
Motion to adjourn. Is there a second? We are adjourned.
Yeah.
Thank you all.